Once again to another program of Issues in the News, where we discuss the important events that would have taken place in Guyana over the past week or so. And as is the norm, we always have a packed agenda of issues to discuss. I want to begin by welcoming our viewers who are joining us on television from West Coast Berbice, Region number 5. Welcome to another program of Issues in the News across the Berbice River. On television again from Region number 6, along the east bank of the Demerara of the Berbice River, New Amsterdam, Kanji, and right across the Quarantine Coast, all the way to Oriala and Siparuta. All of you who are joining us on television, welcome to another program of Issues in the News. To our listeners and viewers who are joining us from Freedom Radio Georgetown, welcome to another program of Issues in the News. And last but not least, to the thousands of you who are joining us on Facebook Live across the length and breadth of Guyana, the Caribbean, North America, Europe, Asia, Australia, Afghanistan, and all those distant places. Welcome to another program of Issues in the News. Share the live, share the program on your Facebook page, on your Facebook account, so that all your friends and family, all your friends and followers can join us in tonight's discussion. Leslie Mongal, Dionanand Sukhdeo, Arjun Jawahir, Mohammed Zakir Yusuf, and a few hundreds of you are already on the live. Share it so that all your friends and all your followers can join us in tonight's discussion. Many of you may recall that some time ago, a few months ago, a gentleman by the name of Troy Garraway filed a judicial review action against the Attorney General of the Cooperative Republic of Guyana. And in that action, he challenged the appointment of Mr. Clifton Hicken as Commissioner of Police. The proceedings was well publicized when it was filed. You would recall that on the 19th of December 2024, His Excellency President Dr. Mohammed Irfan Ali appointed Mr. Hicken to the post of Commissioner of Police in accordance with Article 211(1) of the Constitution. And immediately, opposition leader Mr. Aubrey Norton expressed his intention to file legal proceedings. Well, through his lawyers, Dexter Todd and others, they have filed proceedings challenging Mr. Hicken's appointment. Now, Mr. Hicken perhaps will go down in history as the Commissioner of Police whose appointment has been challenged the most times in Guyana's history. You will recall that Clifton Hicken was appointed to act in the office of Commissioner of Police with effect from the 30th of March 2022. Shortly after that, Jones from the opposition, Christopher Jones, filed an action against the Attorney General and Clifton Hicken, seeking to set aside that acting appointment. The complaint then was that a leader of the opposition was not consulted as is required by the Constitution for such an acting appointment to be made. You will also recall that at the time when the acting appointment was made, there was no leader of the opposition and there was no police service commission in place because there was no leader of the opposition. Because the leader of the opposition is required to be consulted, and the leader of the opposition must participate in the composition of the Police Service Commission. Because of internal wranglings within the PNC, which saw the departure of Joseph Harmon from the post of leader of the opposition, and the election to that post of Aubrey Norton, there was a period in which the post was vacant. And it was during that period that Hicken was appointed to act in the office. As I said, there was no opposition leader for the president to consult. Neither was there a police service commission for him to consult. Both are required to be consulted in the Constitution, by the Constitution, when a person is to be appointed to act in the office of Commissioner of Police. So there was no consultation, and Christopher Jones rushed to court to challenge the appointment on the ground that the Constitution was not complied with because no opposition leader was consulted, neither was the Police Service Commission consulted. We went to court, we had to defend those proceedings, and eventually the Chief Justice dismissed the case and found that the Constitution was not violated, that the police commissioner had to have been appointed, that it was not the fault of the president that there was no opposition leader in place, that there was no one for the president to consult in the form of the leader of the opposition, neither was there a police service commission for the president to consult. And the absence of these two entities could not frustrate the president's power to appoint a commissioner of police to act in office, and that it cannot be in the interest of national security, that it cannot be in the public's interest to leave that office vacant while an opposition leader is appointed or elected, and until a police service commission is appointed. The Chief Justice dismissed the case. Then, as you may recall, on the 22nd of July 2023, Mr. Hicken turned 55 years old. And the President granted to Mr. Hicken an extension to continue to act in office. And the President is empowered to do so under Section 2B of a law called the Constitution Prescribed Matters Act, Chapter 27, colon 12. So under that act, the President has a power to extend the tenure of the Commissioner of Police or a person acting in that office until the age of 60 years old. And the President granted to Mr. Hicken that extension. Of course, the Act also says that the President must consult with the Police Service Commission, and the President did so. Again, the PNC rushed to the court, and this time through Carol Joseph, they sued the Attorney General again, in which they tried to set aside the extension this time of Mr. Hicken tenure in office as acting Commissioner of Police. Again, the Chief Justice ruled in favor of the Attorney General, and after hearing our submissions, dismissed Carol Joseph's case. That there was nothing unlawful with the President's extension of Mr. Hicken acting tenure as Commissioner of Police. That both the Constitution and the Constitution Prescribed Matters Act provide for an acting Commissioner of Police to have his tenure extended by the President. And the Code further found that the President complied with the other procedural formal requirements. So again, that case was dismissed. Then, as I said earlier, on the 19th of December 2024, the President appointed Hicken to the post of Commissioner of Police in accordance with 211(1), Article 211(1) of the Constitution. Again, the Leader of the Opposition announced that he will challenge the appointment, and through his lawyers, Dexter Todd and others, they filed proceedings again against the Attorney General. And this time they are contending that the police commissioner, substantive, cannot be appointed if that person has reached the age of 55. In the case, we filed the submissions, which were filed today, and I've asked my staff to make it public so that the press can get a copy. I have argued very simply, Hicken is not a stranger to the office. He is performing the functions of the police commissioner. And he passed the age of 55. His tenure was extended, not under the Pensions Act, but under the Constitution Prescribed Matters Act. That act has its own regime. And that act permits an appointment to be made beyond pensionable age. The Pension Act has no application to the office of a Commissioner of Police where the tenure is extended. Significantly, the Constitution defines a Commissioner of Police as any person occupying that office, however styled. So whether he's acting, whether he's permanent, that person is a Commissioner of Police. So when the Prescribed Matters Act speaks to a Commissioner of Police, the constitutional definition has to be used. The Act doesn't draw any distinction between an acting or a substantive Commissioner of Police. When they speak about an extension, the Act refers only to a Commissioner of Police having his tenure extended. And as the Constitution, our supreme law, defines a Commissioner of Police to be any person holding the office, however styled. So when the legislation refers to Commissioner of Police in the Prescribed Matters Act, it can refer to any person holding that office. And Mr. Hicken is holding that office, and whatever his age is, he can hold that office until this act says he must not pass 60 years. Throughout the submissions, I have asked the lawyers on the other side, show me the provision that prohibits the appointment from being made. Show me the the provision in the law that says clearly or unclearly that a person who is beyond 55 years cannot be appointed Commissioner of Police. And nobody can point to any provision other than the Pensions Act, which says that a public officer may retire, may, not even shall, a public officer may retire at age 55 years old. That provision cannot apply to the Commissioner of Police, where Parliament has otherwise provided for the holder of that office to get an extension up to 60 years old. It is as simple as that. So these submissions have been filed and served, and a date has been fixed for the 25th of April for ruling. No, 25th of April, I believe we have to go to make oral submissions, and then we will have our ruling. So I thought that I'll share that much with you. Also, you will recall that some time ago, two former judges, Mr. Brassington Reynolds and Franklin Holder, filed legal proceedings against the Attorney General, claiming that they did not receive their rightful remuneration benefits upon retirement. They contend that they were entitled to increases in salaries retroactive in the year that they retired. And consequently, that they were entitled to increased pensions. The matters were heard and determined by the High Court. And we have received two rulings. In one case, it was ruled that one judge is not entitled to any of the reliefs claimed. In other words, the High Court judge who decided the case found that this particular judge did not make, this particular former judge did not make out a case for the reliefs claimed. In other words, he did not make out a case that he was entitled to any retroactive emoluments, and consequently, he is not entitled to any consequential increase in pensions. So in other words, the state committed no error in relation to the computation of his benefits. In relation to the other judge, the court ruled that he was entitled to a retroactive increase because at the time when the government issued the order to pay an increase in salary, he was still on the payroll. So he benefited from the increase. So he will receive an increase retroactive to the 1st of January up to the date of his retirement of that year. However, the court found that his pensions were properly computed. So he only got one of the several reliefs that he claimed in the proceedings. And that judge, that particular judge, is Mr. Brassington Reynolds, former judge, and Mr. Franklin Holder, it was ruled, was not entitled to any of the reliefs. I make these announcements because when these proceedings were filed, a lot of people, first of all, they received wide press coverage, and many persons were very critical of the government. They made all sorts of allegations that against that the government is wrong not to pay judges, the government wants to stifle judges. In fact, one um, one set of criticisms, um, one set of criticisms was to the effect that this was some form of racial discrimination. That these were two Afro-Guyanese judges that were being discriminated against. And we defended the case. They had a very experienced and very respected lawyer. The Attorney General appeared, and they did not succeed in the claims that they have filed. One of them failed completely, and the other one was marginally successful. In fact, we conceded in relation to him that he was entitled to the reliefs. So I share with you this information because when these cases are filed, as I said, they are splashed across the news cycle, and the government comes in for profound and varying criticisms in respect of these cases. And when they are heard and determined by the courts, they turn out to be losing causes. Needless to say, both decisions have been appealed, and we will defend the appeal. Remember, please share the live so that all your friends and followers can join us in tonight's discussions. Now, I don't usually comment on the affairs of other countries in this program, especially the sovereign business of other countries. But when politicians and political leaders and elected representatives of those countries want to comment adversely and make vacuous and unsubstantiated and unfair accusations against my government and my country, I feel compelled to respond. So I saw circulating on the social media some unfortunate and critical remarks that are attributed to U.S. Congresswoman Yvette Clarke of the U.S. House of Representatives. Apparently, she was speaking on a platform hosted by Mark Benshaw. Now that she chose that platform from which to speak, to my mind, raises eyebrows. That she chooses that platform from which to speak, to my mind, conveys a particular impression without even assessing the content of what was said. I have no issues with any elected representative speaking about the affairs of their country, the welfare of people within that country or their constituents, and government policies in that country or opposition policies in that country. I don't take issues with their freedom to speak liberally and critically of those matters. And Ms. Clark said a lot of things about US government policies, which I'll not comment on. Where I part company with Ms. Clark is when she condemns the government of Guyana and is critical of the government of Guyana without being equipped with the material facts and without offering the government of Guyana the facility of a response or even a hearing. So I read this statement, and she's speaking about the young lady who is in custody in the US, Melissa Atwell. She said, Clark stated that she had met with Atwell and acknowledged her fears of persecution if deported to Guyana. And there's a statement in quote, I have heard about this matter. As a matter of fact, I had the honor of meeting this young woman, and this is a travesty. There is no doubt in my mind that it is a travesty. And she goes on to say that this woman will face political persecution if she returns to Guyana. So, how did Ms. Clark come to this conclusion? She spoke to Ms. Atwell and she spoke to Mr. Benchcap. Benchcap is a known critic of the government. Atwell is a known critic of the government. And listening to two critical voices without even expressing any doubt, without extending the facility of a hearing to the government, she has come to the conclusion that it is a travesty. What is a travesty is the way that she has concluded a particular matter and has arrived at a judgment call by only hearing one side. That is what a travesty is. Outside of government of Guyana, was she briefed about the hundreds, if not thousands, of Guyanese unconnected with the government, including women whose characters and reputation and standing and careers have been irreparably damaged and destroyed by Atwell on her Facebook platform, publishing the most ridiculing and damnifying, malicious and falsehoods about innocent persons. She heard the voices of those people? No, she didn't. Did she hear the voice of the young lady who is currently circulating on Facebook, who is explaining that her brother committed suicide because of what Atwell published about him on Facebook? Does she know about the dozens of persons who had to pay money to persons here so that Atwell would stop publishing malicious and destructive materials, false materials about them and their families? Monies that were eventually sent to Atwell in an extortion scheme. She doesn't know about those things. Does she know that Atwell published possibly 20, 30 posts critical of government and government ministers for the past 3 years and was allowed to do so without any form of interference, enjoying all the freedom of speech and freedom to publish that she claims she enjoys? Legal proceedings were filed, yes, but no order, no court order was even sought to restrain her from publishing what she was publishing. Miss Clark did not take time to find out about those things, but listened to one side and concluded that it is a travesty. What is a travesty, Miss Clark, is your approach to this whole matter. Hopefully at some point in time, it will be appropriately ventilated. But let's move on. Last week, it was widely published that the High Court ruled in a particular case involving some minors, Milton Branford, Ayodhya Narain, against the Minister of Natural Resources and Guyana Geology and Mines Commission. The decision of that case, or the ruling of the court, was widely publicized. I spoke with the lawyer for the Guyana Geology and Mines Commission, Cameron and Shepard, and they indicated that they will file their appeal. And today, the Attorney General, acting for and on behalf of the Minister of Natural Resources, filed an appeal against the decision of the Honorable Chief Justice delivered on the 50th of March 2025, and that appeal was filed to the Court of Appeal. I saw emanating out of the Public Accounts Committee's proceedings yesterday some alarming information. Now, many Guyanese would know of the Lotto Fund. I recall for years when we were in government, prior to me coming into government personally, there were allegations always made by the PNC and the AFC against use of the Lotto Fund. And I always recall that the explanation was that every cent that was used from the Lotto Fund was transparently withdrawn, was lawfully appropriated, and spent for a purpose which was made public. under the PPP civic administration. I remember that distinctly. I also remember that Desmond Trotman filed proceedings suing the Attorney General for monies used in the Lotto Fund or from the Lotto Fund. And he lost. He sued the PPP government and he lost. I appeared in the case with Mr. Ashton Chase. I think Mr. Dudnath Singh was the Attorney General. And they lost. And in the news today, I learned that in 2019, and you will note, the government lost its constitutional authority to govern in December 2018 when the no confidence motion was passed. So the government fell in December 2018. So there was no parliament after that. APNU, AFC government withdrew in the year 2019 from the Lotto Fund 728 million. $728 million out of 745 million. They almost emptied the Lotto Fund. Out of 745 million, they withdrew 728 million in 1 year without any parliamentary approval. In fact, Parliament was not even sitting. And these fellas want to lecture this country about transparency and accountability. And their sidekicks at Transparent Institute, their sidekicks like Anand Gulsaran, their sidekicks like Campbell, whatever this guy's name is, Campbell and Nigel Hughes have nothing to say about $728 million blown out without parliamentary approval, without appropriation, without any public scrutiny. 50 million of which was used to finance a Buju Banton concert. 50 million of which was used to finance a Buju Banton concert. This, what I'm reading here, is the worst, the very worst exemplification of financial abuse and executive excesses. This is utter lawlessness. And these are the persons who want to lecture to us, the PPP, and lecture to you about transparent and accountable government. You will recall that they emptied the housing fund in that 5-year period. They emptied the Guyana Forestry Commission funds. They emptied the Guyana Geology and Commission funds. All these are statutory body corporates that have their own accounts. And we left billions of dollars, if not hundreds of millions of dollars, in these accounts, including the Lotto funds. And here it is. In 1 year, they blew out 728 million out of 745 million. And they did the same thing for the housing funds at Central Housing and Planning. They did the same thing at the Geology and Mines Commission. They did the same thing at the Guyana Forestry Commission. So much so that when we got into government, we had to borrow money for the Forestry Commission to pay their staff. They couldn't pay their staff because there was a spending extravaganza of this type. 50 million for Buju Banton concert. And this is after they took the cash grant from the children. They took the subsidies from electricity and water from the pensioners. They put VAT on pension, on water, put VAT on electricity, VAT on school products, VAT on pharmaceuticals and drugs, and I can go on. And today these guys want to lecture us on good governance. I also saw later this afternoon in the news that in the election fraud cases, the argument, well, not the argument, a narrative is being peddled that the witness in the box, Miss Rosalinda Rasool, has admitted that the PPP representatives, the PPP supporters and leaders, the observers and the diplomatic community in Ashmin Building were responsible for quote-unquote chaos as the returning officer for Region 4 was performing his functions. You notice who were causing the quote-unquote chaos? Every person other than Mingo, the returning officer, and the PNC. They named, go read the articles. I read it. They named the observers. They named the PPP representatives. They named the small parties. They named the diplomatic community. Every other person other than Mingo and the PNC were accused by the lawyers of causing chaos. Guess what is the chaos? The chaos was our objection to Mingo using a spreadsheet instead of the statements of poll for the tabulation exercise, as is required by Section 84 of the Representation of the People Act. That is what we were objecting to. The use of a spreadsheet, not the statements of poll. The Bar Association, the Guyana Bar Association was there. The Private Sector Commission was there. The international observers were there. In fact, in the evidence today, I heard on the news that the then president of the Guyana Bar Association, Teddy Usti, was present and he was reading out Section 84 of the Representation of the People's Act to illustrate to the RO, Mingo, what the law says on the procedure. That is, that the statements of poll must be used to tabulate, not a spreadsheet. So Teniusti was reading it. That was part of the chaos. So the Defense Council doing a great job, in my view, in demonstrating to you and reminding you what happened. They spent a significant amount of efforts last week to link Rasul to the PPP simply because when we filed proceedings in the name of Holadar, Riaz Holadar, and Bharat Jagdev, Rasul had sworn an affidavit to support the narrative. And what did Rasul say? Rasul said exactly what she observed. The very thing that she's saying in the court now. And they have the affidavit. But because Rasul swore an affidavit that I drafted, Rasul became an agent of Anil Nandlall and the PPP. And they spent the whole of last week talking about that. But Rasul affidavit is there. I could have gotten an affidavit from Jimmy Carter's grandson. I could have gotten an affidavit from Bruce Golding. I could have gotten an affidavit from Owen Arthur. I could have gotten an affidavit from Sarah Lynch. I could have gotten an affidavit from High Commissioner Chatterjee. I could have gotten an affidavit from High Commissioner Quinn. They all saw the rigging. I could have gotten one from Teniusti. In fact, I may have gotten one from Teniusti for all you know. I can't remember. But these people were simply saying on the oath what they observed. And they would have said it for any party who asked them to say it. Why the PNC didn't ask them to say it? To swear an affidavit for them. They didn't. And they know why. So that case is ongoing, and I invite you to follow it. It's an important case in our country's history, and it's an important case in the evolution of our democracy. I have expressed my view already on the length of time that the case or cases have taken, but better later than never. The trials are ongoing. And the witnesses, and we must not forget that we did a commission of inquiry. You see, these are things that they want to sweep under the carpet. They don't want us to talk about these things. A commission of inquiry was done where we brought two jurists from the Caribbean, one from Trinidad and Tobago and one from Belize. And we had a former chancellor of Guyana. And they concluded that they were dastard attempts by GCOM officials in conspiracy with politicians to rig those elections. That is the conclusion of the report. They don't like us to say that. They want that to be washed away. They don't want us to speak about that. But we have to. And day in, day out, they are defending, not distancing themselves from the attempts at fraud. They are there in the courts defending them. One would have thought that they would have tried at least, if they don't want to accept that they were part of it, at least try to distance yourself from it. No, 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 not at all. They are there in the middle of it, defending it. The leader of the Alliance for Change himself is defending what you and I saw. And that's the beauty of those events. Every day they come back on your phone as a memory. This is March month we are in. It was unfolding around this very time. And 5 years ago it comes up now as a memory 5 years ago on your Facebook page. Look back at it. Look back at it. And you will see how your memories are going to be refreshed. And then you will hear what they are trying to, the narrative that they are trying to inculcate and create in the court. And only tonight I was telling someone that the other fortunate coincidence about what transpired at Ashman's building 5 years ago is that the occurrences took place in a room where the wall was made of glass. So even if you were outside of the room, the glass was transparent and you could have seen in the room. So when they were attempting the fraud, all the observers who were outside could have seen, in addition to those who were inside, because we were actually looking through a glass wall. And what was also of great significance is that there were so many persons streaming it live on Facebook. So that you in North America, in Europe, in Guyana, outside of Guyana, outside of Georgetown, in the building, out of the building, wherever you were, you could have joined the proceedings. And you would have been able to observe everything. Tomorrow, the President will lead a delegation to declare open a brand new edifice at Sodi on the Essequibo coast that will house the Deeds and Commercial Registry Authority for that region. We will have an opening ceremony where His Excellency would be the guest speaker. Before we meet next week, Tuesday, we will be celebrating Eid, which signals the conclusion of the month of Ramadan. So in advance, I want to extend to the Islamic community and my brothers and sisters in Islam, Eid Mubarak greetings. And I always speak about the greatness of the diversity of our religion and our culture. At or about the same time that we would be celebrating Eid, and we will be concluding the holy month of Ramadan, we will begin 9 days and 9 nights of prayers to Mother Durga, because around the same time we will commence Navrat, and shortly after that we are moving into Easter, and that is the beauty of all our religions at play here, 1 week after another, days apart, and we are able to celebrate them all, observe them all, participate in all our cultural and religious practices and precepts with tolerance and with love. And that is something that we must not take for granted. And that is why I always appeal to you that whenever you see that evil hand of division, that evil hand of divisiveness, either on the basis of ethnicity or on the basis of race or on the basis of religion, you have a duty to stamp it out. You have a duty to stamp it out. I want to thank you very much for being part of the program tonight. We will resume next week as we continue discussing the important events that would have taken place in Guyana and elsewhere. Please enjoy the rest of the evening. Take care, and I'll see you next Tuesday. May God bless you. Thank you very much.